Good morning, good afternoon, good evening, wherever you are. I'm Yuri Nemitz, an attorney and a managing member at Nemitz PLC, law firm based in Washington, D.C. This is the sixth of our webinar series dedicated to the problem of Interpol abuse and defending the rights of individuals on the International Wanted List. My co-panelists today are Michelle Aslund of Aslund Law in Miami, Florida, and Ria Ramlogan Suraj. Ria is an attorney at Candela Ike and Jurgens in Miami, Florida. And from 2016 to 2020, she served as the head. She was in charge of the Interpol Notices and Diffusions Task Force. Today, we're going to review the results of the Interpol 91st General Assembly that took place just recently from November 28th to December 1st. As Interpol was celebrating its 100th anniversary. There have been many decisions made and issues considered during the General Assembly. We're going to talk about as many of them as possible today. First of all, Interpol has just admitted one more member country. That was Republic of Palau. Palau is the 196th member of the organization. Interpol has once again surpassed the United Nations by the number of member countries. The United Nations currently has 193 member countries. Palau has been granted Interpol membership based on the General Assembly resolution of 2017 on the process for Interpol membership. That means that, among other requirements, it meets the conditions for statehood, specifically territory, a population, a government, and capacity to enter into relations with other states. Back in 2017, the year when the Interpol General Assembly adopted the membership resolution, based on that resolution, then newly adopted resolution, Interpol granted membership to the Solomon Islands and Palestine. Since then, based on the same resolution and the definition of statehood enshrined in it, Interpol has granted membership to the Republic of Vanuatu, the Republic of Kiribati, which, like Taiwan, lost its membership before that back in 1999, and the Federated States of Micronesia. Somehow, Taiwan's repeated attempts to restore its membership have been unsuccessful. And I think we can all agree that Taiwan is more than qualified to become and to restore its Interpol membership. It satisfies all of the elements of statehood set out in the membership resolution. Not to mention that all this time it has played a major role in legitimate, I want to stress it, in legitimate police cooperation. And it is a democratic country that would, I think, refrain from Interpol abuse, unlike many non-democratic states that have been blocking Taiwan's attempts to rejoin the organization. This proves once again that Interpol's membership process remains a political issue, and the legal requirements set out in the membership resolution apply depending on the existing members' political agenda. The General Assembly has also considered suspension and expulsion procedures and what's, I think, even more interesting, withdrawal for its member countries. And Ree is going to talk about this today. The General Assembly has also reviewed Interpol's regulations concerning Interpol's governance bodies and the work of its working group on governments, and Michelle is going to cover that today. The General Assembly, and again, Michelle is going to talk about this today, considered amendments to its the rules of data processing, the general regulations, and other regulations concerning its structural bodies, as well as improving the quality of data processed through Interpol's channels and the status of red notices and wanted diffusions. I want to note that somehow it's typical for Interpol. It's unfortunately not unusual for them to do so. They have announced that they've adopted amendments to all these regulations, and they have already come into force, despite the fact that they have not been published. During the General Assembly, Secretary General Stock made a directional statement. In it, it praised the organization's technological achievements, among them artificial intelligence, promising to go in further in using technologies to improve and speed up international police cooperation. He stressed the importance of Interpol's neutrality, noted the creation of the Notices and Diffusions Task Force, in my opinion, by far the most non-transparent part in an already non-transparent redress mechanism that the organization has for the victims of abuse. He talked about the Commission for the Control of Interpol's Files, I quote, leading the path to its recognition as an effective remedy mechanism for individuals affected by Interpol's data processing. That is at the time when the Commission still does not have the right to a hearing, appeal, or examine evidence, and it refuses to publish any information on countries' abusers. But it wasn't the Secretary General's directional statement that I think merits attention. It was his interview with Reuters that was published during the General Assembly meeting. And according to Reuters, the Secretary General, during his interview, stated that Interpol has come a long way in preventing abuse, and that, I quote, it cannot do much more for now to improve it. He also, according to the publication, said, I quote, if I got good advice, for example, from NGOs on what else I can do, I would implement that. He has also said, I quote, we have a small percentage, maybe 2-3% of what he called tricky notices. According to Reuters, approximately 10,000 notices are issued every year. So if we take the Secretary General calculations as a proven fact, at least 200 abusive notices are issued every year. And I don't know if the Secretary General includes diffusions in his calculations. He said, I'm not saying it's perfect, but I'm saying it's very robust. I assume he was talking about the redress mechanism. He also did not, according to Reuters, he avoided naming and shaming individual countries. Also speaking of the redress mechanism, he expressed his hope that, I quote, maybe artificial intelligence will help in the future. That is, and that comes from me, instead of introducing basic elements of due process. Also earlier in his op-ed for Euronews, Mr. Stock is quoted as saying, anyone who claims our organization is not treating red notices with the utmost due diligence is deliberately ignoring the facts, close quote. The Secretary General assurances come at the time when the Interpol abuse continues. As an example, according to media reports, Ahmed Jafar Muhammad Ali, I'm sorry for mispronouncing the name, a Bahraini political dissident, was detained back in 2021 on Bahrain's red notice in Serbia. He requested political asylum. The European Court of Human Rights ruled that Serbia should refrain from extraditing him, given the risk of torture and ill treatment. He was still, nevertheless, illegally extradited. He has been imprisoned in Bahrain on 2 life sentences. He has recently filed a lawsuit against Interpol in France. With that, I'll ask Michelle to continue.
Thank you, Yuri. Nice to be here and see both of you. So today, I thought I'd start off by talking about, as Yuri mentioned, the changes that were addressed during this General Assembly for the Rules on the Processing of Development, or RPD. I'll address just a few of the resolutions. A lot of resolutions were passed. And again, as Yuri mentioned, we don't have all of the details that we will see in the coming months, because not everything related to what I'm going to talk about has been made public. So we'll give you what we have so far, and also what we're looking forward to receiving in the future. So in terms of the changes to the RPD, what we do have, obviously, are the resolutions that create the authority for the change. And what we don't have are the reports that gave rise to the resolution. So we don't have kind of all of the background that we would like to have to be able to understand the impetus for these changes. The rules, when they get publicized, obviously will tell us more information, but here's what we have for now. So the first resolution I'm going to talk about is resolution number 8. In this resolution, the General Assembly required the group on the processing information, was previously called, now it's called the Committee on the Processing of Data, to review the rules on processing development. I should restate that this happened back in 2018. So this is kind of a continual process. In the course of this work, the committee submitted a report. Again, it's not publicly available. The resolution that I'm talking about right now, number 8, indicates that there will be amendments to the rules on the processing and development. They do appear to be related to technological developments and advances. We'll need to wait for the actual rules publication to get access to all of the details that are raised there. But in general, when we look at the theme of changes and the statement of intention going forward, the directional statement by Secretary General Stock, we do see a common theme of increased use of technology. I think that's not a surprise to anybody. We're seeing that everywhere across all of our experiences, whether they be professional or personal. Technology is growing by leaps and bounds, so it's not a surprise to see that mentioned in the first resolution that I'm discussing. The second resolution, number 9, addresses improvements in the supervision of data processing. The CPD, the Committee on the Processing of Data, needs to review some proposals regarding the settlement of disputes. Again, we don't have much detail, but what we know as practitioners is that disputes often arise not just between an applicant seeking assistance from Interpol, from the CCF with a personal situation, but there are also disputes that arise between countries. And we very frequently don't hear about them unless we're directly involved with them, but we know that they happen. We know that they need resolution. So this particular change will address disputes arising between member countries and how they might be resolved better. It also requires an improvement on the quality of the assessments of notices and the supervision measures for data related to the member country Belarus. And what's interesting about this particular resolution, or this part of resolution number 9, is that the resolution indicates that Belarus itself issued a report or provided a report that prompted the change. So that will be an interesting change to examine once we get the details regarding this new requirement of the quality of assessments for both diffusions and notices issued by that country or requested by that country. Resolution number 10 is the last resolution that I'll address unless there's something specific that anybody wants to bring up. And that's directed at national central bureaus. It's a very interesting combination because on the one hand, it recognizes implicitly, because it's asking for a change in the improvement of the sufficiency and the quality of data submitted along with diffusions and along with red notice requests. The detail that's being requested, or that's the interest in which is being renewed, are the facts, details of the offense, the charges, judicial documents, all of the things that really the national central bureaus are supposed to be providing. The fact that we're talking about this again, and that there's a resolution directed at it, despite the fact that the CCF has continuously brought this issue up in its reports. Any report that I can think of over the years indicates that this has been a long-standing concern. Maybe later, Yuri and Ria, we might like to talk about the kind of what I perceive to be, I believe you feel the same way, lack of transparency regarding what happens when the national central bureaus don't comply with that. Maybe there are sanctions imposed. We know that there's allowance for that in the rules, but we never hear about it. So not seeing that accountability can affect the perceived integrity of the organization. In any event, we understand from resolution number 10 that there is a continued need for improving data or information that's supplied in a request for a data circulation, such as a red notice. And in the same resolution, it is urged that member countries encourage their authorities and their domestic authorities to recognize these red notices and diffusions as valid requests for provisional arrest. This is now, of course, the resolution recognizes that every country has the discretion to treat a red notice or diffusion as it wishes. I do find it at a minimum interest and probably also troubling that that Interpol is pushing for notices to be treated as provisional arrests arrest documents, when we also are recognizing that we've still got problems with the underlying information that's offered in support of those documents. This particular change that's being urged would actually be contrary to US law. Recent legal and policy changes make clear that US authorities may not treat red notices or diffusions this way. And certainly this request, this change would require many, if not most, Interpol member countries to change their national legislation. So looking forward, we will certainly have access to the rules once they're publicized, although they're already in effect. And certainly, I would imagine that the CCF's annual report for last year, once that's published, may give us some guidance on the impetus behind some of the changes that we're discussing today.
Ria, if Michelle isn't covering her part, do you want to talk about membership and then we'll just go into
Actually,
discussion?
if it's okay with you guys, I'd like to jump in on the comments that
Sure.
Michelle just made about resolution number 10. Um, it seems to me that that was perhaps the most interesting and expansive resolution of the General Assembly, and certainly affects the work that we do on behalf of our clients on a day-to-day basis. And one of the things that, you know, I absolutely agree with Michelle about is that the way in which the resolution is worded causes a lot of concerns for us. One of them is, of course, what she just mentioned, the calling upon countries to use notices as a provisional arrest warrant, which is, in my view, somewhat irresponsible. And then another one, which I find particularly concerning, is simply requesting countries to advise the General Secretariat of the outcome of arrests and extradition proceedings. That is something that is mandated actually under the current RPD, but nevertheless, NCBs are generally inefficient or deliberately do not inform the General Secretariat when the notice should no longer be viable within the system. So that I find really concerning about resolution number 10. And that brings me to the whole question of membership. As Yuri pointed out when he just started, the Interpol is very proud to have added another member country, the 196th member country, the nation of Palau, which has a population of about 18,000 people. We now also know, as Interpol puts immediately on the front page of their General Assembly notes, one country, one vote. So Palau, with 18,000 people, gets the same vote as the United States with 300 million people, with India with 1.3 billion people, and so on, Russia, what have you. Now, what does that mean, though? What does that mean? Well, the General Assembly votes for the Secretary General, the Executive Committee, the members of the CCF, who are supposed to be the oversight bodies of this organization. They approve all decisions, all policies. And one might ask, well, what can you do if one member, one vote? How are we going to change that? How would any organization change that? Give some members more votes? Will it be like the Electoral College in the US? What would be an appropriate way to manage this organization? Well, one appropriate way, it would appear, is by having systems in place to control your membership. There are a couple of resolutions in this General Assembly, I think it's 6 and 7, which sort of one deals with withdrawal of membership, which apparently was proposed by Russia. Another deals with better oversight of suspension and of members. Good. What has happened with those resolutions is essentially it's given to the working group on governance to consider, as many of the things have been given to the working group on governance. So We look forward to them coming up with some suggestions as to how to improve the oversight responsibilities of the organization. But at the same time, one wonders whether, if there's change, will it be meaningful change to the extent that there are already rules in place to establish corrective measures against member countries, to stop them from voting at the General Assembly if they haven't paid their membership dues, or if there have been supervisory controls exhibited on them. We don't know because we aren't there and we aren't given the information, but I would suggest that Interpol, the Secretariat, the Executive Committee exercises very little control in that area as far as keeping the membership responsible and adhering to the rules. We saw last year, and I know Yuri was very involved in this, the movement to suspend Russia from Interpol, which ended up with a very minimal decision, a decision to exercise very minimal supervisory controls over Russia. One questions whether that has motivated Russia to want to withdraw from the organization. I think as Interpol has grown into this huge body, bigger than the United Nations, it is unfortunate that the organization has not kept pace with its responsibilities to exercise oversight over its membership and transparency to the public. Um, one other point I'd like to address, coming out of what Yuri talked about, and Michelle, it's the CCF. The CCF is barely mentioned in the documents relating to this General Assembly. And it is the CCF that perhaps has the greatest power within the current rules of the organization to keep it in line. But the CCF is traditionally underfunded. That we didn't have access to the financial documents. There's a resolution, but we don't see the financial documents as part of this General Assembly. But based on my experience and knowledge, the CCF is notoriously underfunded and notorious and is unable to keep pace with the number of complaints that they get all the time. See, this is an issue that seems to be put aside in favor of the idea of we are one, we are all getting together to make the world a safer place. That's great. But as we all know, at least half of the membership of Interpol is politically unstable, if I might say, and not adhering to democratic principles and the rule of law. Therefore, in such an organization, it is truly important for them to continue to try to improve their oversight of these organizations, of these countries in what they do as far as their membership in Nepal is concerned. I pass it to you, Yuri.
Yeah, I know all the great points. Uh, I just wanted to add to what you said on first of all on membership. I think that in terms of expulsion, interestingly enough, that is not really a new issue for Interpol because they raised it, I believe, last year at the previous General Assembly. They tasked the working group with developing whatever recommendations concerning the a procedure for expulsion because it's nowhere um, it's nowhere found in Interpol's rules, and it seems like they still haven't come up with anything. So they're sort of like reiterating the intent to have it, but they still don't. I think that, and I wrote about it at the time. I think that, and I think it proves my suspicions, sort of affirms them that it will be very difficult for that working group to come up with anything that would satisfy the majority of member countries so that they vote for it, unless the threshold that the General Assembly that the country a country abuser has to meet, so to speak, to get booted out of the organization is so high that it's virtually impossible to meet it. So maybe they will come up with something, but I think that in reality, it will probably never be applied, never be enforced. Maybe they'll threaten one of those countries who like really scum rogue and everything, but I don't think they're really going to enforce it. So that's one thing. In terms of membership, I think that expulsion is probably not the best idea for any of those countries, including abusers, for one reason, in my opinion. It is that despite the fact that the country's abusers do what they do, they unlawfully use Interpol's channels, they do at the same time participate in some legitimate police cooperation, including, for example, rescuing victims of crimes and finding stolen property and that kind of stuff. So if I think that if even one of those countries is expelled, especially if it takes one, if not a major role, an important role in those investigations, it'll probably affect global security. So, and I think that's also a reason why even democratic countries would probably not agree to expelling any one of those abusers in reality. I do think, though, that suspension or introducing measures that would reduce the number of abusive notices from these countries, number one. And two, what I think is even more important, is improving the redress mechanism. I strongly disagree with the Secretary General when he says that the mechanism is robust. It is not by any means. I think we can all agree on that. And instead of expulsion, I think that they should concentrate on these two measures. Um, and Yeah, I think that's on membership. But it's interesting that that withdrawal suggestion of like withdrawal introduced by Russia. I'm not sure what the idea behind that is. Like, if they want to leave the organization, uh, they probably don't need a procedure for
Right,
that.
exactly.
So to me, it seems like a PR stunt. For the lack of a better term. It's like, are they threatening to leave the organization by introducing this resolution? I'm not really sure what all of that means. I don't know how they will be stopped if they want. Any of those countries will be stopped if they want to leave. And I don't think that I doubt anybody is going to close the doors from the inside at the General Assembly meeting. So I think that's kind of silly. That's just my opinion. But on expulsion and suspension, especially expulsion, would be interesting to see what they come up with. Although again, I don't think it's going to be an effective
Right.
mechanism.
I mean, I guess what I would say is that I think it's interesting that they have taken both those points for further study, where there are already processes within the rules, such as corrective measures, which would be more of a stick, if you will, than have the ultimate consequence of those countries leaving the organization. Um, if a country is abusing the way it's using the system, there are ways that they can exercise controls over that country. There are also ways that they can stop countries from voting at the General Assembly if they are not fulfilling their responsibilities as members of the organization. I mean, we all belong to organizations. We don't pay our dues, we don't get to vote. It's as simple as
Right.
that. But there could
Right.
be other, probably innovative ideas as to how else they can look at countries that are abusing the system and giving them less power within the organization. I think it's a fact that some countries don't pay dues because they're too poor to pay their dues. And again, you don't want to foreclose them as having a voice if they're too poor. Maybe there are ways to help with those situations. But for those countries that continually and systematically abuse the system, and one can tell by the number of notices that the Notices and Diffusion Task Force refuses to issue, the number of CCF decisions removing notices that come from them. It is possible to use those measures to come up with some kind of matrix to figure out how to exercise more control over members who are not fulfilling their responsibilities.
Yeah, and I think it's important
Yep.
to for us to maybe talk for a moment about taking our comments within the larger context of Interpol in general. It is our jobs, our respective jobs, to advocate on behalf of our clients, and almost all the time, that means complaining to the CCF about injustices that were imposed upon them that they've experienced, and about things that the member countries have done that are illegal, and violate domestic or international law, that sort of thing. So our job is to complain. But I do think it's important to mention that the reason that we complain to the CCF, part of Interpol, is because it works. So there is a larger picture that we have to acknowledge, which is that, a lot of times prosecutors, police, national central bureaus are certainly doing something that's a necessary service. None of us are pro-crime, right? All of us are pro-law. And the reason that we come to the CCF is because we get relief on behalf of our clients. So when we complain, it's within the larger context of understanding that there is a belief that our complaints will be heard, right? I mentioned that to say that, if we didn't think it was going to work, none of us would do this work. None of us would recommend to our clients, let's try this. Let's go to the CCF and explain the bad thing that has happened so that Interpol can have the option of withdrawing itself from your case. The reason we do it is because it's successful. We have gotten relief for clients and that sort of thing. And it's still true that there is room for improvement. And it's not a heavy lift to be able to say, let's put some accountability in place. And maybe there's accountability that Rio was referring to, that Yuri was addressing. Maybe there's accountability. Certainly, there probably is, that we just don't know about. And the fact that we don't know about it, that it's not publicized, takes away from the credibility of the organization as a whole. I know we've all seen over the last, at least, certainly the last 10 years, that the organization of Interpol has grown in many, many ways, not just technologically, not just in terms of projects they've taken on and endeavors they've engaged in and then decided not to engage in anymore. There's been a lot of growth. And along with that growth has come positive changes, such as the decisions that we see. We see the decisions coming out in a more precise, predictable legal format, that sort of thing. What needs to go along with that is growth in terms of accountability. And I think I have to agree with you, Yuri, when you disagree with the Secretary General about, I don't know what more I could do. Sure. Of course you can. You do know, because we've asked for it. What you can do is have actual accountability that is publicly available. When everybody's being kept honest, people tend to be more honest and they tend to do better. When things can be done in secrecy and nobody knows when you've messed up, probably you're going to continue doing the same thing, because why not? So in terms of the NCBs getting punished and the member countries behaving better, I agree. I don't think a removal of membership or an expulsion is often going to be the right thing, for two reasons. Number one, it doesn't lead to better actions. And the second thing is, we don't want to create a haven for people to go to avoid extradition that becomes a lawless place. I mean, that's not good for any society. So if instead of sanctioning someone entirely and getting rid of them, not dealing with them, if there is a capacity to provide a forum publicly for accountability and also an opportunity for reform, then in my mind, that's something that's worthwhile and certainly something that's doable. Funding is an issue. Ria raised the funding for the CCF. Of course, that's always going to be a problem for any law enforcement organization anywhere. There, you always want to do more with, not enough to do the more. But at some point, when we've got the organization growing as much as it has, and its reach is extending further, and the communications are instantaneous at this point. The effect of those communications can be instantaneous. There has to be a growth in accountability.
What one thing I'd like to put to sort of jump on is this whole idea of funding and accountability. In all organizations involved in law enforcement, and I worked for the U.S. government for 30 years, um, the accountability piece of it always gets secondary attention, because what is sexy and interesting is the work done by the investigations, by the overt actions to arrest individuals. Improving those investigative tools and the tools to effect arrests will always be in any law enforcement organization the priority. But I think all organizations recognize that there must be somebody, who's guarding the hen house. There must be someone looking at the work that those individuals are doing to ensure that they do it according to the rules.
Yeah.
I think that in terms of CCF, I certainly agree. I mean, it is it certainly helps, no question about it, and that's the only venue we can appeal to. I do give it credit for. I think there is. I don't know what's going on behind the closed doors, and I'm not really that interested in it. But I think there is some, at least some tension between the commission and the rest of the organization. Just looking at its publications, at the commission's publications, I think it's pretty evident. The commission has, in terms of funding, it has complained about funding openly at General Assembly, so that you're absolutely right. It doesn't seem like the organization has taken it seriously, unfortunately. But in addition to that, the commission has it has expanded we talked about that there is no right to appeal, but the right to file a request for reconsideration, let's call it a non-discretion, let's call it a discretionary appeal, which it really isn't, but sort of like it. The commission has expanded it. It really did. So, in other words, in certain cases, you don't have to prove that there are new circumstances, some new facts that you were not able to introduce during the initial review. You can just appeal to the commission and say that you've applied the regulations wrongly, or you didn't take the facts right, and so forth. Sort of, kind of like a discretionary appeal. They did that. Again, I give them credit. They also sort of limited the absolute right of governments to block access to the information. Because, as we know, it's a government's absolute right to refuse to disclose the information to an individual, as long as they justify the refusal to disclose the information. But the commission did rule several years ago that this right, actually, as a matter of fact, is not really absolute, that there must be some justification, otherwise they might block the information in the database. They've done that, and I think that proves that there is some tension, for sure, that the commission understands its real role, and that it's not really being recognized as such by the rest of the organization, unfortunately. In terms of membership, I think that in general, the organization, and unfortunately the commission as well, it seems like they do not want to be on bad terms with the governments. So, and when it comes to the commission, I mean, I know we've talked about it on so many occasions. The commission still refuses to publish any information about government abusers. The first and only time they published the number of complaints they received against certain specific countries, there were like 12 or 14 of them, was back in 2010. Since then, they've never published anything like this. Most of the time, they don't publish anything. At times, they just publish in their annual reports the number of requests they receive against certain countries, and that might mean complaints, requests for access, or requests for reconsideration. It's not, these numbers don't really tell us anything, literally. So they're playing with these numbers, but I think it's sort of like there is some unspoken, policy that something, at least not in writing, that they're not doing it, even though the commission is very well within its purview to publish this information. They just don't do it. And the fact that the Secretary General refrained, as Reuters wrote, to name any of the countries abused, I guess except Russia, when he talked about corrective measures, didn't really add much to resolving this issue. But it's true. I mean, the commission. I mean, obviously, yes, it does help. I agree. It's just that the procedure again is so non-transparent. But how about the NDTF? So Interpol continues to promote the NDTF, the Notice and Diffusions Task Force, that they founded, I believe, in 2016, and it's under the General Secretariat. It's not part of the commission. It's a sort of like in addition to the redress mechanism that we already have, that is represented by the Commission for the Control of Files. So far, Interpol has published, it was like 7 or 8 months ago, some numbers in terms of how many requests the NDTF preemptively deleted from the database. Red notices, wanted diffusions, and other requests. And they list, so that publication is on the website, on the Interpol website. It says that some of these requests come from previous years, so it's really unclear what time period they cover. And they do specify that some of them were deleted based on Article 2, some of them based on Article 3, and some of them based on other provisions of Interpol's rules, whatever that means. And I think the majority of those requests deleted by the NDTF were deleted based on those so-called other provisions. And again, I still don't know what it means. If it's not Article 3 or Article 2, so it might be, I know I keep talking about this private disputes provision in the RPD, which we still don't know how to interpret it. I personally think that it should apply to what we as practitioners, I'm sure, deal on a regular basis. I've had a number of cases of illegal business takeovers, including in the former Soviet Union, and when basically what should be considered a private dispute is turned into a criminal case, so that one of the parties that is more powerful and has unlawful connections in the government tries to exert pressure on the other party in a private dispute by opening a criminal case based on a trumped up criminal charge, which leads to a red notice or a diffusion, and so forth. I think that the private disputes provision should apply to that, but does the commission do that? I have not seen one publication on that. And again, there is no official, or to my knowledge, unofficial interpretation of that provision. What do you think about the NDTF role in all of this?
Yuri, you mentioned that the Interpol published some statistics about notices that were removed. I guess I could share some information on that based on my experience at the NDTF. Recalling that prior to 2016, there was very little oversight of the notices which were issued by Interpol. The NCB sent in their requests. There was some cursory review, technical review, and then they were generally issued. So when the NDTF was formed, it was a starting point initially to review notices that were new and coming in for the first time. As the group evolved and better procedures were put in place, and working closely with what was coming out of the CCF, it was recognized that there may be notices in the system prior to 2016 that were never reviewed and were perhaps not compliant with the rules. Not necessarily Articles 2 and 3, but technical rules, for example. And also that, I think I've mentioned this before, that NCBs are not particularly good with following up. They are not, if charges have been dropped, the person has been found not guilty, there's some reason why there's no further prosecution of the individual. they don't follow up. They don't tell Interpol, and the red notice can't be removed. So the other reasons could fall into any one of those categories.
Right.
And I think, it's a project that started while I was there, and I think it continued after I left, to take a look back at all of those old notices that are in the system to see what's happening with them. Are they, were they initially non-compliant, or did they become non-compliant as the years went by? And this is why, like, my sort of soapbox with this issue is Interpol needs to do better oversight with the NCBs. The NCBs start it all, they finish it all. In fact, they need training, and there's a commitment to doing that, but one wonders what exactly that means. They need training, they need to be slapped on the wrist when they don't do the follow-up that they need to be doing. And there should be a discussion with them when there are clear violations, when the cases we are reading about on the front page of the newspaper that should never have been sent to Interpol in the first place. There needs to be some conversation going on with that NCB and the General Secretariat about why did this happen. So yeah.
Yeah, I'm curious to hear both your and Yuri's perspective. Just in line with what you're discussing, it brings to mind the NCB's reluctance occasionally. I've had a few times where they don't want information disclosed to an applicant, and there's no sensible reason for it. For example, they'll tell you the charges underlying the red notice. And when you ask for clarification on asking which article of their law, which of course you can go find yourself, if you aren't able to get the answer from them, but they will object to that information being provided to the applicant. And I'm wondering if you think, as I do, maybe you've got another perspective, that kind of response of requesting, I suppose, their confidentiality or redaction for very simple, basic information that should be provided in order to obtain the red notice is not disclosed to the applicant. I wonder if that type of request comes from something that might be valid, or more likely, in my opinion, kind of a hubris that the NCBs develop because they see that they don't get the slap on the wrist, or they aren't called to task. Not always. I know that sometimes when they don't respond, that affects a final decision. But just in these little initial engagements, when you're getting information, I wonder if some sort of sanction against an NCB might bring them in line to be more transparent where it's appropriate. If there's an ongoing investigation, that's a different thing. I understand there can be justifications, but to not provide certain information just to kind of play cat and mouse really seems beneath the behavior of what I think an NCB should do. I'm curious about the both of your
I think in your experience as a criminal attorney dealing with government attorneys, I think it's sort of the same dynamic, if you will. It's like the less we share, then the greater the chances that we're going to catch the criminal. And I personally, that's just my personal view. I think that that's partly what it is, because those kinds of decisions are generally not made by the officers of the NCB.
Mm-hmm.
If you're asking a legal question, or the CCF is asking a legal question of the NCB, they're going back to the prosecutor.
Yeah, and they should have the article, in my example, they should have the article that's alleged to have been violated readily available. And obviously the NCB or whoever is leading up to them is asking that not be disclosed. And it doesn't seem to me that there's a valid basis for that kind of a request, other than habit.
But it seems like so if we're talking about the provision that they're not disclosing, you're talking about the criminal charge.
Sure, that the name of the charge, and this has happened several times, the name of the charge will give you, but not the article number, not the code number. It's an odd thing.
Yeah, it's really odd. I mean, and it also seems to me like it's a violation of a flagrant violation of the International Covenant on Civil and Political Rights, because I believe it's Article 14. You have the right to be informed of what you've been accused of. So like how do you conceal that information? I mean, it's not about disclosing the details of an ongoing
No.
investigation. I mean, somebody has been charged. Based on that, there is an arrest warrant, which based on which there is a red notice or or a diffusion. That's really that's really strange. And maybe the commission doesn't consider it a big deal as long as the individual knows what the charge is. But then when we submit our complaints to the commission, and that's according to Interpol's rules, I believe, the governments have to, when they use Interpol's channels, they have to comply not only with the Interpol Constitution, not only with Interpol's regulations and rules in general, but, and that's in the Constitution and in the RPD, in Article 2 of the Constitution says it's clear that the governments have to comply with their national
Yeah.
laws.
Yeah.
So when we often provide, our arguments are often based on the analysis of the national law, why it hasn't been applied in the right way and so forth. So disclosing this, not disclosing this information is really weird. But in terms of membership and NCB's not being responsive and not being compliant, I mean, that is typical for even for democratic countries, as interesting as it is. Because, like, again, if we look at Spain, where, according to media reports, I think the majority of all of those, almost the majority, a big number of those arrests that have taken place, that have also made it, in the media, been executed. There were several years ago. There were two activists who fled Turkey at some point, EU citizens. Then there was Bill Browder arrested. It seems like, I don't know all the details, but it seems like it was on old information. Spain just doesn't seem to delete it, even after red notice is deleted based on Article 3.
Yeah. And I don't think
So
we can, I don't think it's reasonable, or no, it's reasonable. It's not realistic for us to expect that every offender is publicly sanctioned in a transparent fashion. I think that we have to make a comparison of, for example, any law enforcement agency that has its internal affairs division. We know that in order for an officer to be truly sanctioned, there have to be not only a lot of complaints, they have to be substantiated, and it has to be almost shocking to the conscience before we get to the level where we find out that someone has been punished in any meaningful way. I ask for these kinds of internal affairs records all the time. I'm sure the two of you have done the same. And we find out that it's the worst offenders who get the punishment, but they get the punishment and we find out about it. And so I think that what we're collectively discussing is not what might be considered a tiny, nitpicky accountability system for each and every bad act, although of course we would love that. But realistically, the worst of the worst offenders, that's a reasonable request.
Well, this comes back to the transparency point, right? It's not
This is
that I think we are entitled to know every time an NCB gets a slap on the wrist or gets, talking to by the General Secretariat. But what I think we are entitled to know is there's a process in place to do that.
Yeah.
And that the General Secretariat routinely does it. And maybe at the end of the year, they say, we, based on complaints we received from the CCF, from individuals, NGOs, we have taken action in 50 cases or 20 cases, or, we've looked into 100 and found them unsubstantiated and have taken no action. That's what organizations do when they want to be transparent about their processes. But with Interpol, it's all in secret. It's all a big secret.
This is it. And whenever I'm trying to explain to someone what the definition of injustice is, I always go back to that feeling you get in your gut that, oh, this is wrong. And even a child, if you've got anybody who's a parent, has more than one kid, knows that even when you're disciplining a child, if one comes to you with the complaint and you say, okay, I'm going to take care of it, I've disciplined the other child, I'm not going to tell you what happened. That child's going to wonder, did you really? What happened? That's not fair. I want to know. Those are just kind of basic instinctive feelings in calling for fairness. And if it's that basic and that simple, I don't think it's that difficult to solve. You know.
Well, I mean, there is an example of that. What just Michelle just said. Look at the lost and stolen travel documents database, right? I mean, Interpol has issued several, if not not resolution, maybe not resolutions, but public statements, whatever. I think there were resolutions as well, where it reaffirmed the importance. It was basically reminding the governments that they have to comply with the SLTD regulations because they were abusing them and still abuse them. And if I know if Ali Yildiz is watching this stream, I mean, he is an attorney who specializes in the SLTD abuse. Maybe he has something to say about that. But I remember there was one of the resolutions that Interpol issued was they were basically telling the governments, there was something along the lines, we have just issued another guidance on how to comply with already existing regulations. It just, so in other words, instead of punishing, it seems like instead of punishing these governments, they're just reminding them that you have to, please do that. It's like, again, going back to being children, treating children. If you put a bowl full of candy next to a child, say don't touch it and leave the room. I mean, and that's pretty much it. It doesn't seem to be effective. It seems like the whatever corrective measures that the rules provide for, they apply in I mean, they enforce them. Interpol enforces them in really exceptional cases. Again, just looking at what's been going on in the past several years, Afghanistan. After Taliban came, Interpol all of a sudden decided to restrict their access. Russia again, fall in 2022. It's something. It seems like they need a war or some major change of a regime to something really horrible to actually act on it, as opposed to countries that continue to abuse it. It's sort of like maybe they consider that abuse more or less harmless, so to speak, taking into consideration the numbers. And it's not the first time that Interpol brings up this argument that, well, we have thousands of these notices and only several hundred are abusive. And it doesn't really help much because these are people's lives. Again, we just talked about the case of a Bahraini activist. I mean, he seems to be a young man who's been sentenced. It's 2 life sentences in Bahrain. I don't know what his chances of being released at some point. I hope he has them, but it's several hundred a year. That means over 10 years, it's what, several thousand. How many of those are going to be caught by the NDTF? Plus, again, there is no regulation on how, at least not publicly available regulation or guidance or anything on how NDTF, maybe Ria knows the answer to this question, if there are any guidelines that except, of course, which we know, like the Constitution and RPD, of how the NDTF conducts its checks. Because in my understanding is that they are limited to what's in the public domain about the criminal case and what's in the database and whatever the government is ready to give them. And of course, if it's an abusive notice or a diffusion, I assume the government wouldn't be interested in disclosing all the information about the case so that they can truly appreciate the entire context. So it's sort of like all of this. Plus, they, of course, they do not inform the individual in question about the investigation. So they only get this like one-sided view of what's going on in a case. There are still many loopholes in the mechanism. I know we've been talking about so many times. It's just that unfortunately, Interpol chooses to, again, for the lack of a better term, spin instead of actually addressing these issues. And all these public statements coming from the Secretary General or Interpol's public relations or whatever it's called, press office, when they say that we before the Secretary General's interview with Reuters, I know the press office had said on several occasions that we constantly, I'm not quoting, it's like paraphrasing, but the point was that we constantly work on improving our redress mechanism. And then you have the Secretary General coming out and saying there is nothing else we can do. So it's truly shocking, even by Interpol standard. I think that interview was, to me, was maybe not an eye opener. Not that I was shocked, I was surprised by them not really doing anything, but even the public relations approach to all of this isn't really sort of in sync. I think we've covered a lot today. If anybody has questions, feel free to put them to post them in the chat now. If not, you can ask them later in the comments or whatever, and we'll gladly answer your questions during our future webinars. I want to thank Michelle and Rio for the great conversation. It's really interesting, and I'm sure we'll continue to cover all these topics, including this General Assembly, when the organization decides to publish the regulations. I want to finish our webinar today on that point. When it finally publishes the regulations that, I want to stress, according to the organization, are already in force. We would love to know how our clients' rights are affected by the regulations that you have not published as of now.
Thank you for the forum, Yuri. Thank you for inviting us.
My pleasure. Thank you for joining me, and I hope we'll do it again soon.
It was a pleasure.